Hi, good morning. Thank you so much for joining our webinar today. My name is Jessie Peterson. I'm the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We are a national construction document service. Today's webinar is conducted by the incredible Rebecca Hicks, a Texas construction lien law expert. Today's webinar topic is Mechanics Liens Texas Style, deadlines and forms of notice to get paid. So without further ado, I'd like to introduce the fabulous Rebecca Hicks.
Good morning, everybody. Sorry I was a few minutes late. Traffic in downtown Dallas is a mess this morning, but we're here and we're going to talk about one of my favorite subjects, and that's because I'm a sick construction lawyer, mechanics liens. Let me tell you what we're not going to be able to do today. Texas lien law is some of the most complicated and intricate lien law in the entire country. So you will not get a comprehensive view of every detail of Texas lien law today. What I hope you will leave this seminar with is that you know what your deadlines are and have a general idea of what the notice and the mechanics lien, the information needed for one of those, and what they should look like. As Jessie mentioned, I'm a construction lawyer. I'm board certified in construction law. I've been doing these lien seminars since about 2002, actually. So I've been teaching and learning about mechanics lien law for a long, long time. You're not going to hear all those details today. When we teach a seminar that actually covers, most of the subject matter, you're talking about probably a full day seminar to kind of get the broader picture. So we're just going to hit the highlights. The important stuff which is what's my deadline and what do I need to know to get my mechanics lien filed. Okay, so here's kind of what we're going to talk about in the order we're going to talk about it. Step one, you can't even begin to perfect a mechanics lien claim unless you have good project information. Step two, what's your deadline? That's the other important thing you got to know. Step three, how to perfect the claim. That's what we're going to be talking about. So step one, how are you going to get, what project information do you need and how are you going to get it? The first thing you're going to have to know, these are what I call the big three questions you got to know project-wise, because today we're only going to be talking about mechanics lien claims. And so those only apply to private projects. They do not apply if you're doing any kind of government work or federal government work. So if you're doing state and local government work or federal government work, what we're going to talk about today is not going to apply to you. It's only going to apply if you are working on private projects. So you're always going to need to know who is the owner, because you determine the rules that apply by who owns the project. So you've absolutely got to know who owns it. What's your position in the construction chain? Because if you don't know where you sit, you don't know who you've got to send notice to. And you might skip someone that you've got to send notice to in the construction chain. That means you've got to know from the person that owns the dirt or the entity that owns the dirt all the way down until you get to where you are in the construction chain. You've got to know who all of those parties above you in that construction chain before you get to the owner are, or you can't notice early, right? Right. You've also got to know for these private projects, is there a payment bond? All government jobs are bonded, but a private project can be bonded. It's up to the owner and the general contractor what they negotiate as to whether this project is a private project is going to be bonded or not. So you always want to be asking the question, is there a payment bond? Is there a payment bond? So what kind of project is it? And these are the types of projects that you could be working on, right? These are really the only four options out there of what type of project it could be. Private works. What does that mean? It just means it's privately owned. It means it's owned by a company, say an LLC or an Inc., or it's owned by private individuals. that's privately, it's not owned by a governmental entity or a government related agency. So the other types you can work on would be state local works projects. So if you're doing street work for the city of Dallas, that's going to be a separate rules apply to that. We're not going to talk about those rules today. If you're working on federal public works projects, like you're working on army bases or those types of things, post offices, again, those are even separate rules. We're not going to talk about those. There can also be public-private partnerships. Y'all probably heard a lot about PPPs in the last several years. It's kind of getting to be a more popular way for projects to get built. And public-private partnerships are simply where a private entity and a government entity work together to get something built. Like a lot of times it'll be applicable to like maybe a tollway. Here in Dallas, we have the Clyde Warren Park, which was a public-private partnership. Those types of projects are going to be treated as government jobs. So again, we're not going to be talking about those rules today. The only rules we're going to be talking about today are number one, private works projects, something that's privately owned. So when we're talking about private projects, pretty much anything that's commercial construction is going to be privately owned, right? So if it's a shopping center, it's you're building an apartment complex, you're working on somebody's home, those are all going to be private projects, right? If it is the applicable law, what we're going to be talking about today, where you find the rules that relate to these private projects, is in Chapter 53 of the Texas Property Code. So everything we're talking about today is taken directly from Chapter 53 of the Texas Property Code. I would say, hey, go read that, check it out. But honestly, the way that our statutes are worded, you have to read it like 4 to 5 times just to even start to understand what the legislature was trying to communicate. They didn't do a great job of making it crystal clear. We'll put it that way. The language is stilted. You have to read it 15 times. You have to go back and look at, oh, what's the definition of this word? But I'm going to try to boil it down for you so that you can at least know what your deadline is, what your notice needs to look like on these private project claims, right? Right. So here's what I mean when I'm talking about a construction chain. This is what I mean. It's just in construction, it's contract to contract. Who contracts with whom? It starts with the owner. The owner then hires the prime contractor or the original. This is, the traditional delivery system, right? There are other options for delivery systems, but we don't really have time to get into those intricacies today, such as design, build, and those types of things. We're just going to go with the traditional model since this is a shorter seminar, right? So when we talk about the traditional construction model, this is what we're talking about. It's just who contracted with whom. Owner's going to have contracted with the prime or general contractor. Then the prime contractor is going to be contracted with those first tier subcontractors. Usually you've got your plumber, your electrician, those types of things. And then those contractors, those first tier subs, then may subcontract it down further, certain parts of their scope of work, until it gets to the end of the construction chain. Sometimes at the end of that construction chain is the suppliers. So those that provide the product to either the second tier or first tier subcontractors. So it might be a supplier. But you're going to be who contracted with whom until you get to you in this chain. That's what you need to know. So is there a payment bond? That's our third important question, right? We talked about what kind of project is it, how you're going to tell. You're going to have to know ownership. We've talked about, too, what type of project are we talking about? And now we want to know, is there a payment bond? Some of these private projects are bonded. There are certain types of projects that are more likely to be bonded, have a payment bond posted by the general contractor or not. The types of projects that we really should kind of perk up to see if there's a payment bond if you're working on, is if it's a very large job. Let's say it's a private hospital. So it's not a government owned or a government run hospital. It's not like Parkland here in Dallas, but it's a private hospital. Most jobs that are of that type of scale, the owner is going to require the general contractor to post a payment bond. So that you generally want your ears to perk up and be really pushing this question on any jobs that you're working on that are really large. The other types of jobs that are generally bonded If it's a large subdivision, it's a development of a large subdivision you're doing. Let's say you're doing road work on what will be a pretty large subdivision. Those jobs are generally bonded. So like I say, these private projects can be bonded if owner and general contractor, that's what they agree, but they don't have to be bonded. Most smaller types of private construction jobs may not be bonded, but you won't know unless you ask the question. Government jobs are always bonded, either federal or state or local government jobs are always bonded, and there are separate rules that apply to perfecting those bond claims. So that's kind of the way that this works. But there also can be, just be aware of this. Well, first of all, let me just kind of take a step back. What am I talking about bonded? We're talking about a payment bond. What is a payment? A payment bond is basically the equivalent of an insurance policy purchased by the general contractor, or could be purchased by a subcontractor, that from an insurance company, and it says it's for the protection of the subcontractors and suppliers that are below that person in the construction chain. That says, hey, Mr. Owner, if I do not pay my suppliers or my subcontractors, here is this insurance policy, i.e. payment bond, where the surety is promising to pay them in my stead if they perfect a claim properly. That's what a payment bond is. It is basically an insurance policy where a surety is on the hook to pay for the work that you may have done or product that you may have supplied on a construction project, as long as you get your claim perfected properly up to the amount of the bond. A payment bond that is a Chapter 53 payment bond has to be in the full amount of the job. So it has to be in the full amount of the contract between the general contractor and the owner. So the surety would be on the hook to pay the full amount of the job should that GC fail to pay, should that subcontractor then fail to pay. Sometimes what the general contractors do when an owner requires them to provide a payment bond, because they're expensive, right? There's going to be a premium attached to that. It adds expense to the job. But the general contractors are more and more often these days pushing that risk down to the first tier subcontractor level and requiring the big subcontractors to post payment bonds as well. So then the general contractor is saying, hey, you have a big piece of this job, Mr. Plumber. You're going to need to also go out and buy a quote unquote payment bond, which is the insurance policy from the surety that says, hey, I'm going to pay the subcontractors and suppliers below me in the construction chain. And so though that is a different type of bond, that is a subcontractor bond. So we're not going to be talking about that today, but that you just need to make sure you know that concept is out there, because it's another way that you can get paid on these construction jobs. Right. So what is a payment bond? I forgot I had this in here, but it's just an insurance policy purchased by, basically the equivalent of an insurance policy purchased by the general contractor to protect the owner and making sure that folks below it are getting paid. So I call these gotcha types of bonds. A lot of times you'll see when you ask, is there a payment bond on a project? And can I get a copy of that? A lot of times what you'll get is kind of two bonds kind of squished together, because that's the way a lot of times they're issued by the surety. That's a lot of times the way that the folks at the owner or general contractor are keeping the copy. And there'll be a performance bond and a payment bond kind of in the same PDF document that they send you. You don't care about the performance bond. Why? What is the performance bond? The performance bond is a separate insurance policy purchased by the general contractor for the protection of the owner that says, hey, owner, if I, as the general contractor, don't complete your job for whatever reason, the surety is going to step in and either complete the job itself or hire a replacement general contractor to complete your job. So the only party that's really benefiting from this, a performance bond, is the general contractor. So if you look at the top of the bond, that's where you're going to see the title of what type of bond it is. If it says performance bond, That's not what you're looking for if you're trying to assert a bond or lien claim. You are looking for the payment bond. So that's the one we talked about, which is the insurance policy that's going to pay subcontractors and suppliers if the general contractor fails to pay. So now we've got to talk about, well, okay, you know it's a private job. How are you going to get the information you need in order to perfect a mechanics lien claim? My recommendation is that you use a job information sheet. If you don't have one, feel free to steal this one. You just need to, if you get all of the information kind of on this job information sheet, and best practice is to get this information up front while everybody's still getting along, while the money's still, there's no money disputes, there's no performance disputes. You want to get this information in on the front end. Don't wait until payment is past due. So you're going to want to know who are you contracted with all the way until you get down to the owner. You've got to know this information. The other important information that you want to know is specifically, and this is a problem a lot of times, if you're a subcontractor or you're actually out on the project performing work, it usually isn't an issue. You know exactly where the project is located. You should at least know the address and how to get there so that you can look it up, on real property records. But sometimes suppliers have a hard time with this because they're not on the job. And maybe the delivery address is an address next door because it's new construction and there is no address. So you've got to make sure you know exactly where your product was used. If you're relying on a delivery address, that may not be the correct address for the actual project address. You've got to know exactly where your project is, what kind of project it is, and where it is. Because for you to have for a valid mechanics lien, you're going to have to get in there the correct project address and ideally a legal description for that project, or at least a partial legal description for that project. And you can't find that information if you don't have the address for the project or exactly where it is. Beware, I see clients mess up all the time by relying on a delivery address that really was a plot or so down the road or across the road. It was an easy delivery or staging area, but wasn't the actual project. You got to know where your stuff was used. So how are you going to verify this project information? If you complete that job, have your customer or whomever you're contracted with help you complete that job information sheet for every project and do it up front. That's best practice. You can also, what we end up doing for clients where they do not have that good project information, and quite frankly, we verify any project information that's sent to us anyway. So if we're trying to perfect a mechanics lien or bond claim for a client, and how do we do that? You can, a lot of searching online and calling the contracting parties. Call the general contractor. Who exactly did you contract with on this one? What's the exact name on your contract? Who owns the project? And is there a payment bond? Those are the questions. That's the conversations you want to be having. You can find a lot of this information online now because you'll be able to see who's talking about working on the job. General contractors a lot of times have the project listed on their website as something they're working on, so you can verify who's the general contractor that way. Ownership records, you can always find that stuff online. As long as you've got a good address, you can run it through the Central Appraisal District records and do not stop there. Let me give you this word of caution. Central Appraisal District records do not tell you who owns a piece of property. And they can be wrong, and they can be at least a year out of date because they really only get updated at tax time, when it's time to figure out who needs to pay the taxes. So once you kind of know what you're looking at, you actually do need to go and try to find a deed for the property. The only way to really tell who owns a piece of property is to look in the real property records, which most counties in Texas have them online now, and find the deed. Find the deed. The most recent deed is going to be where you actually verify ownership of the project. Where are you going to send these notices? So we were talking about, who's in the construction chain, one of the things you've got to flesh out is, okay, what's a good address? Because you're going to have to send a notice letter. Texas law still requires us to send snail mail lien notices via certified mail return receipt requested. You're going to have to send a letter. It's going to have to go to the right address via certified mail. How are you going to find the good addresses, the right addresses for those parties in the construction chain? One thing you can do is any sort of incorporated entity or limited liability company has to be registered with the Texas Secretary of State. Their entity has to be formed with the Texas Secretary of State, and they have to provide the Texas Secretary of State basic information about their company, such as they have to provide their principal place of business. They have to provide an address for a registered agent for the company. Those are the two addresses for any incorporated entity that you want to get onto your notice letter. So what's the easiest way to find that stuff? In Texas, we have a service called SOS Direct. It's a subscription service, but the subscription fee, you pay a couple dollars per search or something like that. It's a very low fee to run a search. Maybe just $1. I can't remember. It's very low. But you do have to sign up for the service. So it's not like a monthly charge. You pay as you go. You just pay for the searches that you run after you've got a subscription. And you run those names. When you've kind of gotten the names of who you believe are in the construction chain, you run it through the SOS Direct website, and you get that principal place of business address and that registered agent address. Those are the addresses that need to make it onto your notice letter, right? Right. So let's talk about the biggie. What's my deadline? Because this is where most folks mess it up, is by missing the deadline, because they come up faster than you would think on these jobs. So, lien, bond claim, deadline summary. This is our for a private project. This is a summary of deadline by person in the construction chain. The general contractor only has one deadline, because the general contractor is contracted directly with the owner. They don't have to send any sort of notice before filing a lien, because if the owner's not paying them, the owner obviously already knows that. That's what the law thinks, right? So if you're contracted directly with the owner on a job, only deadline you have is to file a mechanics lien affidavit by the 15th day of the 4th month after the last time you did work on that job. And what I mean is substantive work, not punch list work. So if the last time you were doing substantive work on a job that you would bill time for, or bill the customer for, bill the owner for, not punch list, that's when you want that clock to start ticking on the 15th day of the 4th month if you are a general contractor. Now for first tier, second tier, anyone below the general contractor, it's a 2-step process in Texas now. And I say that because it used to be a 3-step process for second tier subs and below, but now it's only 2. So you've got to, as a first tier subcontractor, you have to send what I call a fund trapping notice letter, but it's a statutory form of notice. And we're gonna go over what that statutory form is and what it looks like here in a little while. But you've got to send that fund trapping notice letter by the 15th day of the 3rd month after each month that you do work on the job. And keep in mind, this 15th day of the 3rd month and 15th day of the 4th month does not run from your pay application date. It does not run from your invoice date. It runs from the month you did the work, you performed the work. So if you're billing a month later, you've got to be looking at the month you performed the work or the month that you delivered the product. Do not rely on an invoice date. It has to be the month that the work was done or the product was delivered. So that notice letter's got to go out. And it goes, the fund trapping notice letter goes to everyone above you in that construction chain. So that's why you need to know the construction chain, right? Because you've got to get that notice letter in the hands of the if you're the first tier sub, you've got to get that notice letter in the hands of the general contractor to a good address, and the owner on the deed at a good address, right? Second tier sub, same thing. You just got to send that notice to one other party, right? You got to make sure that first tier sub is also on your notice letter. So that's the deadlines you've got. So then for first tier and below subcontractors, you've also got to get that mechanics lien on file by the 15th day of the 4th month after the last month you did work on the job, right? Correct. You may have to send several fund trapping notice letters. If you keep working on a job and you're not getting paid, you may have to send more than one fund trapping notice letter because you've got to send it on the 15th day of the 3rd month after each month that you haven't been paid for. But you're only going to ever need to file one mechanics lien because that 15th day of the 4th month deadline for the mechanics lien runs only from the last time you performed substantive work on the project or the last time you delivered product for the project. Hopefully that makes sense. So this is what I mean about we used to have a 3-step process if you were a 2nd tier sub or below. We used to have in Texas what we called a preliminary notice or a 2nd month notice. That is no more. That went away, I think about 4 years ago, 2 legislative sessions ago, if I recall. But it's in the legal world, that's still pretty new, right? That's the first substantive change to the notice requirements in Texas for years and years, for about the 20 years I've been practicing, that's really about the first substantive change to what notices need to go out, the notice deadline. So it's still a relatively new change, but you no longer have to send the 2nd month notice in Texas. It's only the 3rd month notice that needs to go out. So gave us 1 more month of breathing room, right? So this is kind of how those deadlines will look for you though, right? If you've done work in January or provided product that was delivered in January, then you've got to make sure that notice letter is going out to everybody above you in the construction chain on or before April 15th. And so that's that's the deadlines we just had to deal with, right? When we sent out our notice letters in April, those notice letters were going out for January work or January product delivered. So you can kind of go down. The reason why I give you guys this chart, because this is something that you can kind of look at and go, okay, what's my deadline? Instead of having to go, what the 15th day of the 4th month, what does that mean, right? And then for that January work, that mechanics lien would have to be filed on or before May 15th. And so here is the kind of the working chart for Texas now, since it's only a 2-step process. You've got for your January work, you're sending that notice letter April 15th, and you're getting that mechanics lien on file with the real property records on or before May 15th, on down the line. These are the deadlines you need to be working from. So for a subcontractor, 2-step process. You've got that fund trapping notice letter, 15th day of the 3rd month, that lien affidavit being filed with the real property records, 15th day of the 4th month, 1 month later. But it's 1 month after the last day you did the work on the job. But you also do need to send notice of your filed lien affidavit within 5 days of filing. So for a lien affidavit itself, it's not a letter that gets sent out. It is a sworn form that we're going to go over that contains certain information that the statute says it's got to provide, and it is filed with the real property records in the county where the project is. So you actually have to, most filing now is done electronically, e-file, e-recording, it's e-recorded, electronically recorded, but you can still physically record a mechanics lien if you have an original signature and you physically provide it to the county clerks. In most counties, they'll still take paper, but it's a lot easier just to e-record it, right? But that actually has to be recorded. And what that means is the county clerk receives the mechanics lien that you've sent to them. That's in your statutory, contains all the statutory information, and they file stamp it so that it has a date on it. They give it a document number, and then they index it so that it is recorded against the piece of real property where the project is. So it shows up in the real property records like a mortgage. It is a lien against that property, equivalent to kind of what a mortgage is once it's recorded. So that's kind of what you're doing with a mechanics lien. For if you are the party that's contracting directly with the project owner, that meaning you're the general contractor, you're the original contractor, there's only the one deadline, the 15th day of the fourth month. If you want a statutory lien, 15th day of the fourth month, your lien affidavit has to be recorded by that date. But you also just keep this in the back of your mind. If you somehow miss that statutory deadline as a general contractor, we have a concept called the constitutional lien in Texas. And that's a self-executing lien that only a general contractor have. You have to have that direct contractual relationship with the owner. You have to have been doing work for the owner. But it's just a claim that you can make, an additional lien claim that you can make. If you somehow miss that statutory deadline, you may still have a lien. So what are your steps to perfect a claim on a private project? Third month, notice to owner, GC, and anyone else above you in the construction chain. Fourth month, you got to get that mechanics lien affidavit on file before the 15th of the month, on or before the 15th. Then you've got to send notice of that filed lien. And so you remember we talked about the mechanics lien has got to be recorded with the real property records. Well, how are the other parties going to know that you did that? You have to send them notice. You have to send them a certified letter that says, hey, here's a copy of this recorded mechanics lien. That can go out within 5 days after you filed the mechanics lien. So you've got a little breathing room to get it out after it's actually filed. But you do have to send that out certified mail. Then if the lien gets paid, at some point you will have to sign a release of lien. If the lien is not paid, you'd have to file suit to foreclose the lien. If the lien is not paid, the deadline to file suit to foreclose the lien is the best deadline to go from 1 year from the date of filing. You want to get a lawsuit filed and served within 1 year of the date of the file stamp on that mechanics lien. That's what you need to do. So let's talk about, well, okay, we talked a lot about this. Notice it's got to go out on the 15th day of the third month. What the heck does that notice need to look like? Texas made our life a lot easier when they made those substantive changes, getting rid of the second month notice. They gave us a form, a word for word form to use. Before, everybody was just kind of doing their own thing. The statute kind of provided you with some information that had to be in the notice, but they didn't say your notice needs to look like this. So everybody was kind of had their own manuscript type of letters that they were sending out for these lien notice letters. That is no more. When the legislature gives us a word for word form, they do that because they expect us to use it. There's actually a part of the statute that says if you send a notice that's substantially different than our form that we nicely provided for you in the statute, word for word, then it's not going to be enforceable. You're not going to have a good lien. So do not keep using your old form. I don't care if your form contained a lot of the same information, just in a different spot. I don't care if your form contained more information. You think it's even better than the statutory form. Do not use your own form. Use the statutory form. And I believe if you're working with SunRay, that's what they're using. So, but if you're doing this stuff in-house, use the form. And so the next few slides are the language copied and pasted directly from the statute that is the statutory form. The only thing you're going to be adding to this form is the addresses at the top with the certified mail numbers. So you're going to be adding certified mail numbers for everybody, certified mail numbers and addresses for everybody above you in the construction chain to the letter. But that's all you're going to add. Otherwise, you're just going to stick to the form. So this is the first part of the form. And yes, this warning has got to be at the top. If you don't have this warning at the top, you don't have a good claim. You got to have the date. You got to have the project description and address. And you got to have the claimant's name, which is obviously your name. You're the one, your company's the one making the claim. Then you've got to have the type of labor or materials provided. And this doesn't have to be a super detailed description. Let's say that you are supplying electrical supplies. You don't have to list out every type of breaker, conduit, etc. that you provided. You can just say electrical supplies, including conduit and breakers and lamps. You don't have to list out all the technical details. You can if you want to. If it's a very big claim, it may make sense to do that, but you don't have to. Then you have to put in the original contractor's name. So that is, who's contracted directly with the owner. And note that it only says their name. It doesn't say address, it just says name. Party with whom, and then you've got to put in the party with whom you contracted if you didn't contract directly with the original contractor. So if you're a second tier sub, this is where you would put in that first tier sub's name that you contracted with. If you're contracted directly with the original contractor or general contractor, I usually just put in their name here as well. You don't really have to because you've already put it up front and it says if you didn't, but I usually will just put it there just to be safe. You have to put in the claim amount. The important part about that claim amount is you want to make sure it's correct. Get the math right. Make sure your claim amount's correct. You want to then put in the claimant's contact person. When we do claims, we generally will identify our law firm as the contact person because we're representing that company. So we would say, let's say we're representing ABC subcontractor. In this section, we would put ABC Supply Company, care of Rebecca A. Hicks at Hicks Law Group, and put our address. Then you want claimant's address. So notice that claimant's name is up above, but now it's again asking for claimant's address separately. Don't know why they separated it. Doesn't really make a lot of sense, but that's the way the form is. So don't change it. Just leave it the way it is. Fill it in. Now the statute says you can include copies of the invoices or billing statement. So I think best practice is to attach your invoices to the notice letter, the unpaid pay applications or invoices. You don't have to, but I think that's best practice to go ahead and get those in there. That also, if anyone ever tries to argue that you didn't describe your product sufficiently, if you've got invoices in there, they're generally going to have the good product, a detailed product description in there, or a detailed summary of the work that was performed. So best practice is to attach your invoices to that notice letter as well. So who gets this third month notice? Everybody above you in that construction chain. What addresses do you want to send to? Owners. This is the way we do it. And, lawyers are risk averse, right? And we're generally working on larger claims because we don't get hired unless it's a larger claim, generally speaking. So we want to make darn sure that notice gets into the right hands. You have to kind of judge from, your perspective as a business owner or business person, how detailed you want this to be. But this is best practice how we do it. For the owner, we will generally send to the address that's on the central appraisal district for that owner. Then, if different, the address on the deed that we have pulled from the real property records. Then we look for the address that was provided when we were filling out our job information sheet. So somebody has provided us an address. If that's different, we will include that address. Then, you remember we talked about looking on the Texas Secretary of State for information. We include the registered agent and the principal place of business that we were able to find on the Texas Secretary of State records. And we also include email addresses for anyone we have contact with at the owner that we have a good email address for. Now, the statute does not say anything about email notice. So you are not required to send any sort of email notice. Email notice is not legally effective to effectuate a claim. So you're going to have these other physical addresses. We're still dealing with snail mail here, people. The legislature, this last session, the last several sessions, there are bills that get introduced to try to let us hey, can we just kind of email these notices so we're not doing a lot of printing and killing trees and causing everybody stress around the 15th of the month? And it has not gotten through. It'll get reintroduced this session, I'm assuming, and it probably still won't get through. That's just where we are right now. The legislature has not caught up with technology. But my experience is if you include the email addresses along with these other addresses, the physical addresses, that the email gets there faster and often gets you results and paid faster. So there's nothing wrong with including the email addresses, just don't rely on that solely. You still have to have those physical addresses, right? So for the general contractor, who are you sending to? Job information sheet address, registered agent, principal place of business from the Texas Secretary of State, and in the emails that you have there. Same thing for these the subcontractors below you, right? The subcontractors above you, I should say. Form for delivery of notices. The best and the cheapest and the cheapest way to get these notice letters out and have them be effective under Texas law is still going to be certified mail return receipt requested. Registered mail is no longer a thing. I don't think anybody was using it anyways, but the statute used to let you use registered mail. That's no longer a thing. You can't use that anymore. But the best way to do this is certified mail. The statute was also amended last time to say you could use FedEx, UPS, or those type of receipted delivery services. Anything that's a receipted delivery service like that, you can use those instead of certified mail, but they cost a lot more. So the most cost-effective way is still to do a certified mail return receipt requested. And again, the email is great to have in addition to physical addresses, but it's not effective under the statute as good notice. Now, so we talked about getting that mechanics lien, the untrapping notice letter out. 50th day of the third month, it's gone to all those addresses, certified mail. You've used the statutory form. Great. Still haven't gotten paid. You're no longer working on the job. So that was your last work on the job. You've got to get your mechanics lien filed by the 15th day of the fourth month. So a mechanics lien is a sworn affidavit that has to be filed with the county clerk and recorded in the real property records. So if you don't know, where that is, you can always just Google it and find real property records, place where do I need to record my mechanics lien in whatever county, and find it really quickly. You can e-record in most counties in Texas, but you have to sign up with the e-recording service in order to do it. Not a big deal, but you do need to do that. Some counties still require physical filing. Some of these smaller rural counties, and it's only a few, it's only a handful now, still require actual physical copies. And so you have to know in advance if you're going to have a physical copy of a mechanics lien recorded, because what does that mean? You're going to have an original signature, notarized signature, mechanics lien affidavit physically delivered to that county on or before the 15th day of the fourth month. If you wait until the 15th day to figure out if you can e-record it, you're going to be screwed, because you're not going to be able to get that physical copy there in time. So just check in advance. You have to know filing time if you have to send a physical copy. One of the big gotchas is not sending the clerk enough money to get it recorded. These county clerks charge a filing fee for these affidavits for mechanics lien. There's usually a fee for the first page and then a fee for every page after that. And it's the first page costs more and the other pages are much smaller. That, these liens are costing usually $30, $40 to get recorded. So that's kind of how it works. And if you don't pay the fee, if you have to send a physical copy and you don't send that money with the affidavit, they won't record it and you've missed a deadline. So now let's talk about this mechanics lien affidavit. What does it have to say? What does it look like? Here is what the statute says. The legislature did not provide us with a form, a word-for-word form for a mechanics lien affidavit. So you just have to make sure that your mechanics lien affidavit, the form that you're using, includes all of the information listed out in the statute that it's required to include. So this on the screen, this slide is the language specifically from the statute that's listing out exactly what's got to be in that mechanics lien. It's got to be a sworn statement of the amount of the claim, the name and last known address of the owner or reputed owner, a general statement of the kind of work that was done and material furnished, and then each month in which the work was done. If you're not contracted directly with the GC, you've also got to include in that affidavit the statement of each month when the work was done. So sometimes folks will skip over that part. The name and last known address of the person by whom you were hired, you were working for. Who were you working for on that job? The name and last known address of the general contractor. And then here's the part that gets messed up. A description legally sufficient for identification of the property sought to be charged with the lien. That's why you've got to know project address and hopefully a project legal description. If you have found the deed for the property, you're going to have that legal description. What we do on our mechanics lien affidavits is attach the actual meets and bounds description from the deed as an exhibit to the affidavit so that there's no doubt as to which property we're asking to be charged with our mechanics lien. Do not rely on CAD for this. CAD's a good source to get you started on your research. Does not determine ownership, can be up to a year out of date, and oftentimes contains wrong information. You've got to have then the claimant's name, your mailing address, and if different, your physical address. So if you're one of those that you have a mailing address and you have a separate kind of office address, but you just get your mail at a different address, you got to have both in this mechanics lien, right? For a claimant other than the original contractor, a statement identifying the date each notice of the claim was sent to the owner and the method by which the notice was sent. This is also where I see people skip this in their mechanics lien a lot of times. You've got to tell them, you've got to summarize those prior notices. Let's say you've sent 2 fund trapping notice letters before you sent this, before you had to file your mechanics lien, because you weren't paid for several months. So you sent more than 1 fund trapping notice letter. You got to get that summarized in your affidavit for mechanics lien, or it's not going to be a valid claim, or arguably not a valid claim. And here on your mechanics lien affidavit, again, you can attach the written contract that you were working under. It's not required, but sometimes it's helpful. You can attach the invoices that are unpaid. I think that's a good idea. We generally do attach the invoices to these affidavits when we file them. That's going to increase your filing fee. It's not 100% required, but it solves a lot of problems just getting those invoices attached. Here's just a couple of the e-recording services if you're trying to do lien affidavits in-house so that you can e-record. You just have to look at their websites and see what's required to get signed up with them. And that way you could electronically record mechanics lien affidavits and not have to, physically show up at the county clerk's office with your money. So once you've got that mechanics lien affidavit filed with the real property records, you have to notify everybody in the construction chain above you that you have filed the mechanics lien, and you've got to get that done within 5 days of having filed the mechanics lien. And that notice has to go out again by certified mail, return receipt requested, or FedEx or UPS, one of those services, a receipted delivery service or certified mail. And a lot of times this step gets missed as well. Folks are real focused on getting that lien filed, but then not taking that next step, which is notifying the other party that you have made the filing. So please don't skip this step. It will invalidate your lien. So that was really the big stuff I wanted to talk with you guys about today. I'll be happy to answer anybody's questions. There's a lot more to Texas mechanics lien law, but that's the biggies, deadlines, and what does my notice look like?
Yes, Texas can be very tricky. Thank you so much, Rebecca. That was really wonderful. There was a lot of meat and information in that presentation. So thank you so much. We do have a question that has come through. It says, can a lien be filed on a homestead in Texas?
If you meet a lot of contractual requirements, yes. Is the deadline the same as a commercial job? No. The deadlines for notice is 1 month earlier. The deadline for filing the lien is 1 is 1 month earlier, so 15th day of the 3rd month. But you can't even begin to try to lien a homestead unless you have a contract in place with the owner that says a bunch of very specific stuff laid out in Chapter 53. And then that contract has to be signed. If it's a husband and wife, both have to have physically signed that contract document. There's certain things that you have to have recorded in the real property records, and then you can proceed with trying to get your mechanics lien on file. There's a separate form in Chapter 53 for mechanics lien on a homestead project. It has to have some additional language on it, but that language is provided. The notice letter and the lien look slightly different. It's possible. It's hard to do.
Okay, thank you very much for that clarification. Another question came in, not necessarily about liens. It says, is there any specific language you would advise to include in your contract to protect you in dealing with tariff increases?
What is called an escalation clause. And you can probably just kind of ask AI about these. That if you get a contract provision that basically says if the price goes up above whatever you could take, right, above, if the price goes up more than 7%, the price goes up more than 10%, whatever that pain point is for you, then we get to renegotiate, or we get to charge you that increase. Yes, you can definitely get that into your contracts, and there's a bunch of different forms for an escalation clause is what it's called.
Okay, perfect. Thank you. And then another question that popped up is, does the mortgage take priority over the recorded lien?
If the mortgage is on file before the work began on the job, then yes. In some situations, what you will find, though, is somebody, the title company, messes up. They don't get that mortgage filed, and there's already construction happening on the site. In certain situations, even if the dirt work starts before that mortgage is recorded, then your mechanics lien can actually jump in front of the mortgage. So you have to look at if there's any doubt at all about, the date this mortgage was recorded and when the construction began. Look at it very carefully. I've won cases on those before just by proving that they started the dirt work before the recording date on that mortgage.
Okay, wonderful. I do believe that that's all the questions that have come in. If anyone does think of another question that wasn't addressed, please feel free to reach out, and I'll be sure to answer any questions that come in. Can you go to the next slide for us, please? All right, here are some of SunRay's resources to help you stay organized, know your deadlines, and secure your lien rights. So go ahead and scan that QR code to access these incredible resources. As Rebecca showed in the presentation, there's a job sheet. You can have your own job sheet. We have a free one on our site as well. It really helps you guys get the information that you need early in your project to know, all the entities that are upstream above you, and make sure that you're getting everybody notified properly. So please check that out. And then if you don't mind, go to the next slide for me. All right, our next webinar with Rebecca is going to be Thursday, August 28th. I filed my mechanics lien. Now what? Turning that lien into dollars. And then we have another one, October 30th, payment bond claims and private and state government projects, the basics. So please sign up for free at sunraynotice.com/education. We'd love to see you guys there. Those are going to be really informative and great. And then the next slide, if you don't mind. All right, if you don't mind, take a moment to give us a review on Google. We really appreciate any of the feedback you're able to provide to us. It helps us always better ourselves and some of the content that we're putting out for you. And then the next slide. Thank you. And with that, that is all we have for you guys today. Thank you so much to everybody who attended. We hope to see you at our next webinar. Again, Rebecca, you really are incredible. So thank you so much. I appreciate it. I hope everyone has a beautiful and wonderful sunny day. Thanks, everyone.